arms and stated he called the mother of his child so he could pack his belongings and leave. Defendant stated he was upset because complainant would not take him to get food and admitted when complainant called and attempted to call 911, he took her phone to prevent her from contacting the police.
Mr. Henderson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using illegal drugs, including marijuana, I will revoke your bond and put you in jail. You are not to have any contact with the complaining witness in this case. Do you understand? Yes or no?
Yes, sir.
You are not to be in possession of any weapons as well. I'm entering now what's called a magistrate's order for emergency protection that identifies Ms. Thomas as a protected individual. You cannot commit family violence or an assault against this person. It's probably a good idea for you to listen and not be in la-la land, Mr. Henderson. You violate this, they can file additional charges against you. You are not to have contact with this person. You're not to threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the 3443 Clouding Road apartment. Do you understand?
Yes, sir.
If you violate these conditions, that they can file a violation of a protective order against you. It's one of the worst cases you can pick up, sir.
I understand.
Hey, do you mind printing? This is Mr. Thomas. I'm sorry, Mr. Henderson. Do you mind printing out the MOA so I can write no contact on it, please? Mr. Henderson, do you have the ability to hire a lawyer? What do you do for a living?
I do TikTok.
What does I do TikTok mean?
I'm a TikTok creator.
Okay.
I'm an affiliate.
What kind of money does that earn you a month?
It's not more than $800.
Okay. Then you need to get a job. A real, legitimate 9 to 5.
Yes, sir.
Your attitude tells me a lot.
Not to be an attitude. I can do nothing and I know I'm not here to speak about anything.
You have the right to remain silent, but your attitude tells me.
Keep calm, sir. I didn't do anything really wrong. They're not going to tell the full story about whatever happened.
Stop.
I'm just chilling. I'm not trying to be a victim, so I'm just accepting what's happening. Going on about the business. Okay.
I'm trying to keep my calm with you, Mr. Henderson.
Okay.
If I lose it, it's just not going to go well for you. I'm giving you the expectation now. You need to get a job. There's no more use of any alcohol or illegal drugs. You pick up any more cases, I'm telling you now, I will keep my streets safe. And if I have to throw you in at a high bond, I'm going to do it in a heartbeat and I will not lose sleep over it. You understand me? You don't get to sit at home playing Xbox all day while everybody else in Harris County has to pay for everything for you. Do you understand? It's just not an argument. This is not a negotiation. I'm telling you what the expectation is. You either live by the conditions or you die by the conditions. I'm going to bring you back in 2 weeks, and I want to see what you have done to get a job. You will be tested. If at 40 days from today.
Okay, we're barely 4 minutes in, and Judge Fleischer is already dropping wisdom. You either live by the conditions or you die by the conditions. That's not just a courtroom line. That's a life motto. And notice how he doesn't yell? That's way scarier. Quiet, certain, and absolutely done with excuses. Buckle up.
You test positive for anything illegal, it's not going to go well. Do you understand?
Yes, sir.
Come on.
Yeah.
Your Honor, those were the pre-trials?
Yeah, he's gonna be monitored.
All right, Judge, top of 12, Reyes, come on up. All right, go ahead and sign for your receipt. Financial officer?
No, I got one.
Oh,
Yeah. So you can go ahead and appoint him a lawyer, but back in 2 weeks.
Henderson. Reyes, top of 12.
Mr. Reyes, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of high blow. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 4th, 2026 at 2:03 a.m., officer was dispatched to a residence in Harris County, Texas in regards to a violation of a protective order. Witness stated his son had a protective order against the defendant, and the defendant violated this by driving to the street to honk and yell, including coming up to the front door to yell. Witness also stated defendant appeared intoxicated while driving a white Honda Accord. Officer was in a marked patrol vehicle when he witnessed the car matching the description, driving down a public walk at a high rate of speed with the lights off. Officer pulled over the car and witnessed defendant with red floppy eyes, slurred speech, and a strong odor of alcoholic beverage from her breath. Defendant refused to leave the car and was only identified when officers ran a victim protective order, which read defendant is not meant to be at 260 feet of the residence or the communicate with the officer observed an open beer can in the vehicle. Defendant states that he is defendant's boyfriend and he had dropped a previous charge for assault and that the protective order shouldn't be in his system. Officers conducted standard field sobriety tests. Results were 6 out of 6 HBN, 4 out of 8 walking term, and 3 out of 4 one-night stand. Defendant provided a breath sample. Results were 0.174 and 0.165.
The prior aggravated assault, the prior aggravated assault that was dismissed less than a month ago. Same complaining witness. Tell me, was there alcohol or?
You can look at it right now, Your Honor.
And then she has a prior aggravated assault with family member, same complaining witness from the one 4 years ago.
Different complaining witness, Your Honor. And I'm taking a look to see if there one of the complainant is involved in the alcohol.
Yeah, drinking. Ms. Reyes, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
Yes, Your Honor, her license is.
One more, and I'm going to revoke your bond and I'm going to put you in jail. You understand?
Her license is eligible, and it's taking a look at the prior aerosol, Your Honor, it does not seem like alcohol was.
There was. Ms. Reyes, I'm going to find that there's probable cause. You were ordered not to consume alcohol or illegal drugs. You will get a SCRAM monitor on your ankle, so I know that you're not consuming alcohol. And I'm forbidding you from going within 1,000 feet of where the complaining witness in this case lives or works, and you will get a GPS monitor on your ankle, so I know where you are. If you go anywhere near this person, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my streets. You do anything to violate these conditions, it's just not going to go well for you. Do you understand me? If you have a problem with drugs or alcohol, now is the time for you to address it. Because if you don't, and it becomes a problem, I'm going to do it for you, man. You have the ability to hire a lawyer. See if I have an application. I need you to fill out an application. I'll take a look to see whether you qualify. Deputy willing to give you an application. You will sign a reset, and then we're going to have you meet with your bond conditions, and then we'll take a look at you to see whether you qualify for a court-appointed lawyer.
Is she allowed to drive?
With an interlock. There has to be an interlock on the car. Yeah.
All right, Judge.
And
the last
insurance
one is
as well. I
on
want
page
proof of insurance prior to.
John, come on up.
Oh, no weapons.
17. This is Kelly.
Good morning, ma'am. Ma'am, you're charged with cruelty to animals. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 2nd, 2026, officer was assigned to review a case authored by HSPCA regarding premeditated force and deceased soul in Harris County, Texas. On May 24th, 2025, officer responding to a downed horse when he observed a different emaciated horse. Upon opening an investigation, he found the horse to have a body condition score of 1.5 out of 9. Officer also witnessed the deceased bull. A 3-day notice was written for vet care for the horse.
Did you say a deceased bull?
Bull, FOA.
Oh, full. Okay.
Upon returning on May 26th, the horse was still in the stall and the note was untouched. The foal was still there with flies around it. The next day on May 27th, there was no contact with the owner, so the note had been removed. The deceased fowl had also been removed, but the horse was still in poor conditions. Officer called defendant after getting a phone number from the bar manager who claimed ownership of the horse since July or June of 2024. Defendant stated the horse had been skinny since she got it and had cognitive documentation. Defendant stated she saw the note on May 25th but did not read it. Defendant also stated she was aware the horse gave birth. In a supplement, the detective stated that he spoke to defendant who stated she knew the horse needed vet care but did not read the notes, so did not notice the 72-hour time frame despite disposing of the note. A vet examined the horse and found the body condition score to be a 1 out of 9. The vet found that this was likely due to starvation. This was likely starvation due to malnourishment. The vet stated.
Did you catch that? Defendant says he's a TikTok creator, making less than $800 a month. And the judge's response? You need a real legitimate 9 to 5. Harsh? Maybe. Realistic? Absolutely. Question for you. Should judges be this direct about someone's career choices? Or is that crossing a line? Comment below.
Likely that there was also likely dental neglect and total.
Do we know that it was hers?
She claimed ownership of the year.
She did?
The bar manager also provided the number for the defendant.
So it's on the mayor then.
The barn manager identified defendant as the owner of that stall. Or the owner of the horse, Your Honor.
Okay. Ms. Young, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to have any care, custody, control of any animals. You understand? If you violate this condition, I will revoke your bond, put you in jail. No more PR bonds, man. Do you have the ability to hire a lawyer? Are you working at this time? Stop. I just need to know whether you can afford a lawyer or not. So what I'll do is I'm going to have Deputy Williams give you an application. I'll take a look to see whether you qualify. You have to be at the federal poverty guideline level to qualify for a court-appointed lawyer. I need to know. So we'll just have you fill out an application. Please be honest. You're going to swear to it, and then I'll take a look to see whether you qualify. Please, no animals. Do you understand? Now's not the time. You need a lawyer, and the lawyer can help you navigate through this. But now I've got a bunch of DAs here. Whatever you say, they're going to try to use it to prove guilt. Okay? Please. No care, custody, control of any.
Yes, Your Honor.
Hi. Come on. Yes, sir, please.
Judge, I'm question. I'm Brandon Ventura.
Ventura. Okay.
Hey, to bother with this, but, need to go to the proper channels and you're at, what we
Don't be
have-
sorry. Whatever you want to do is not a problem.
We have a bond condition, regarding curfew. And I've given your pretrial supervisor and prosecutors some documents that reflect that it would be a much better arrangement if that curfew was changed a little bit to allow for him to continue working as a garage door installer. What we were asking for originally was changing it. Right now, it's from 7 to 7, changing it from 9 to 9. Your pretrial supervisor pointed out that because he actually is not necessarily required, they're giving him some leeway at work to get there a little bit after 9. But if he was going to be perfect employee, the curfew would actually be 8:45 or 8:30 to 9:15. So that's an expansion, but the employer can live with just the same 12 hours instead of 7 to 7, 9 to 9.
What say you?
I just wanted to report, Your Honor, the defense provided proof of his.
And if it matters, Judge. the
Okay. No, I mean, that's
compliance.
what my next question was going to be. You know, I just need some kind of proof that he's actually going to do these. Do you see it? No. Veronica, I trust you. So you've seen it?
Yes.
Okay. Had there been no violations so far? Okay, I'm all right with it. You know, baby steps, right? Tell him
Yeah.
just no violations, just no contact and
Correct.
Yeah.
Thank you.
no weapons.
And he's been made aware painfully so. And
Great.
there is a court appointed lawyer on the case right now. I have been able to reach out to her. I did file a notice of appearance and
Oh, great.
a record. She has my permission as related to the coordinator to sub me in or sub out or whatever.
So wait.
I've made an appearance.
So you are going to sign on to these cases now, both of them.
I am on this case.
Are you-
And upstairs.
Wonderful. That makes it a lot easier.
Thank
Okay. Who is it? We can also try to reach out to them as well to see.
I'll be happy to sign
Yeah.
on the kiosk and generate it. She can just.
Okay.
sign.
Yeah, for sure. Go for it. Yeah.
Oh, and how is July 21st?
So it's counsel. Do you want 9 to 9? Is that what you want?
I was hoping for 8:30 to 9:15. That would.
So
actually
8:30
get there on time. instead of-
8:30.
Yes, Your Honor.
So he's got to be home 9:15
Correct.
until,
8:30 in the morning.
okay, I'm okay with that.
Perfect.
Yeah.
Thank you.
Sure.
Did you talk to Chelsea about the
Counsel. Good morning, Mr. Began.
I was told we need to approach on Garcia because it's getting old.
Yeah, you're at 200 days.
So.
Where we
there's
headed?
There's a felony, it's unrelated to this case, but it is, the 248, and we're still getting, it's a ag assault. If there's,
Is the same complaining witness?
nope,
Okay.
it's completely separate. What happened, if you remember, this is one where,
I don't remember my,
what happened was, he was shot. He was shot. Well, anyone that shot, he is shot. He was in the hospital. I approached you because he was in custody in the hospital. He got a
is this,
bond.
did he shoot himself? Is this when he's cleaning a gun? No? Okay, just a random,
It was someone shooting back at,
got it.
it's from the shootout.
Okay.
That's at 48. This should be set to July 21st. I told the prosecutor today that this case is, the felony is probably a year away from getting anywhere.
And we can't hold it that long.
I know,
So-
and what I told the prosecutors made an offer of 30 days, we rejected it. I made a counter offer at the time. There's two charges. There's a assault and then there's a criminal mischief. I made
Is there
it-
any restitution in the mischief though? I certainly will give you more time, but at some point we got to say when. So, but I'm happy to give you more time.
This, I appreciate that. To me, this is a case, this case, we can do standing right.
Sure, it's, I get it, I understand.
So my counter offer was dismissal or a time served on the criminal mischief. But right now, I'm not, I isn't that just.
You got, yeah,
That's what we are.
We did confirm that, criminal mischief, we still have a valid for.
okay, I need to know if there's restitution. So between now and the next setting, do you mind reaching out to complaining witness to see? Well, I mean, the goal is hopefully a global resolution. I don't know if that's still, because yours is just so new. I mean, it's 4 years or 4 months up there and these take for,
No,
right, so,
I knew that it could be an
Sure.
issue and so, you know, if we have to try this before, we can, but it's one that.
I understand. We'll give you some more time. Don't worry. Just hopefully between now and I don't know, is there still a lot of discovery that's outstanding upstairs? Okay. All right, we'll just give you after the July
Yeah.
and then just keep us in a loop.
What I've been doing is I set it on the same day, then we come back down and get it.
Sure.
And then.
Sure, of course.
So we.
Sure.
Again.
Just please look to see if there's, my concern is everybody should be made whole. If someone has their stuff broken, really, it's only fair. This is, upstairs is what they're really worried about. This is, right? But nevertheless, restitution support, you know? Okay, all right,
All right.
have fun. Let's move on. Hey, give me one second. Back again, back again.
He came up clean today.
But it keeps happening though. Mister, come on. Come up.
I spoke to him.
So he tested today?
I spoke to him on the phone the day he missed. And I spoke to him about 12:30, he said, I'm gonna leave about 1:30 to go. And he called me again.
I'm happy that you're negative, man. Really, I'm extremely happy. Just try to do better, man. I'm trying my best not to put you in, you know? I'm happy that you're negative. That's great. One day at a time. Just please.
I've seen traffic.
All right. How are you getting point A to point B? Are you driving? Are you?
Right now, I'm cleaning, driving, I have to get drove and move back sometimes, like I took Uber, but we got stuck in traffic and made it here late.
How are we are we still doing Mondays and Thursdays?
Yeah.
Okay. How long has he been negative for?
I'm sorry?
How long has he been testing negative? Has it been just a couple weeks, 3 weeks? No, it's not been 3 months.
He
3
was
weeks.
in drug.
I'll make you a deal. The next 2 times, if you show up on time and you're still negative, we'll change it to once a week randomly. So you don't have to come 2 times a week. All right? But trust is so easily broken and very hard to get. And I'm willing to work with you. Just keep it, stay clean, one day at a time. Just don't miss. And then next 2 times, if you're okay, once a week, randomly. Okay? All right, man. All right. Good luck, Mr. Good luck. Thanks. Hello? Hey.
Sounds like. I'm sorry. Sorry.
You and my son. Hey, I'm sorry, my AirPods are picking up. What's up, buddy? What are you watching? No, I know. What are you watching? Okay, yeah. I just sent you money. I just sent you money. Just use the Apple Watch. Okay? All right. Okay. Bye.
Judge, can you send the transfer order for video so we can send them it for the tenant?
Yeah.
Yeah, what's back there? I'm getting really I haven't even showed up for the today. But I'm just coming to make sure that this
You're welcome. Okay, okay, sounds good. Yes. Yes.
My phone's off. So SOS.
Is, emergency.
No, come back. You can keep it in the
Yeah. I'll be right down.
It's a good problem. I gotta get a job. So my TikTok experience, don't in jail, getting 13 free meal, my TikTok time to step it. So it's kind of like, it's not. Okay.
It's a lot.
I'll probably consider your, I think. Just because I do the more with it. No problem. And then, yeah, just let him know they decided on the kid right this. And then, so no, she's got to go for the. And then,
Wait! Do we just hear deceased foul and horse with a body condition score 1.5 out of 9? For context, 1 is emaciated, 9 is obese. This horse was basically starving while the owner didn't read the note. Fleischer's face right now? That's the face of someone who loves animals more than excuses. Coming up, the library laptop incident. Stay tuned.
oh, that's all done. The, and then you bring it. It's like, she had it's gonna be, it was recently important.
And, I get what she had. When is it? It's good. Okay. You're that's mine. I'm like.
So you can act with me. I'm making this one up here. I'm taking this one.
So, hey, he was disrespectful to you?
He was helping, I was fine, was listening, he wasn't ready to speak, and
Did you feel threatened at all?
I did not feel threatened, but, I was not giving instructions.
Yeah, no, by all means. Okay. I don't know. We'll see. We'll let him calm down for a while. We'll see how it goes.
I will say this, I asked him if he had a phone, and he's like, I don't have a phone, so I'll see if he has a phone, he's like, it's out.
Okay. We'll let him chill for a while.
When this name just became. Yeah, for
Yeah. Judge, whenever you're ready, I have two cases.
Okay, let me just send this real quick.
Yeah.
Hey, what was that dude that we took him back? What was his last name? Anderson? Oh, Henderson, right.
Page 6.
Okay, I'm ready when you are.
All right, Judge, the first case number is 2623109.
Okay, Miss Davis, come up. Oh, sorry, I need you, please.
2623109.
Good job. Miss Davis, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 1st, 2026, officer was flagged down by a reportee in regards to disturbance at Harris County, Texas Public Library. A complainant was security and reported the incident. Defendant was cussing at an employee / yelling at her. Officer heard the incident take place. Security screamed, "She needs PD." Officer observed a university laptop flying through the air, hitting the ground. The laptop was valued at $1,200. The witness observed defendant throw the laptop off the table. Complainant, the manager stated the value of the laptop and wanted to press charges.
Okay. Miss Davis, I'm going to find that there's probable cause to go back to, or probable cause to go forward. You were ordered not to go back to this library. You understand?
Yeah.
You are not to have contact with the complaining witness in this case and not to be in possession of any weapons. You already missed court once. You have a warrant for your arrest at this time. I will recall this warrant, but I'm not going to do it again. If you miss court again, you will go to jail. You understand?
Yeah.
I don't know who you have in this life, Miss Davis, but if I have to put you in jail at a $10,000 bond and you don't have anyone to put up that kind of money, it's probably not going to go well. You understand? Yes or no? I'm not asking much. I want my streets safe. You need me to appoint you a lawyer today, ma'am. Okay, do you mind creating those bond conditions, please? Do you mind please appointing her an attorney?
Yes, Judge, are we reinstating?
Yeah, we'll reinstate the bond now. You got the constable? Yeah, okay, thanks. Ms. Davis, for now, I'm going to have you sign a reset. We will have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign the bond conditions and we'll find you a lawyer, ma'am.
Okay.
Come on.
Judge, I have another case number when you're ready.
Okay, let me just write this down real quick.
Oh, I think that. I'm just doing it.
Okay, I'm ready.
All right, case number is 26222289.
Come up, Mr. Lawson. Mr. Lawson, you now stand charged with driving while your license is suspended or revoked. You're facing up to 6 months in jail and or a $2,000.
Hold on. Someone threw a laptop across a public library because they were upset? Ma'am, that's not criminal mischief. That's a tantrum with legal consequences. And the laptop was worth $1,200? That's a felony in some states. Let's do a poll. What's the most unhinged thing you've ever seen in a library? I'll go first. Someone return a book late. Wild, I know.
$1 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 28th, 2026, in Harris County, Texas, officer observed defendant driving a vehicle with no vehicle registration sticker displayed on the windshield. Officer had knowledge that defendant had been offered a vehicle with a suspended driver's license and had no financial responsibility. Officer also knew that defendant had open misdemeanor warrants.
The officer knew that he had misdemeanor warrants?
Yes,
Is that what you said?
I believe the officer recognized.
Oh.
The traffic stop was conducted and officer ran defendant's driver's license, which was found to be suspended, and also found no proof of financial responsibility.
All right. Mr. Lawson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive any vehicle whatsoever for any reason. You will be signing an affidavit promising me that you're not going to drive. Do you understand? You have missed multiple courts, multiple occasions. You're on bond for an assault, and you now picked up another case. I'm not going to give you another PR bond. You will be going into custody today. But at this point, do not drive. Okay, we'll appoint your lawyer today, and then I'll have you talk to someone here momentarily. All right? Okay. Guys, you ready?
Good morning, Judge.
Come on. Good morning.
It's an off-docket, Judge.
Okay.
Case number whenever you're ready.
I'm ready.
It's 2622290. The last name Town.
Tally?
Yes, Judge.
Okay.
One out of Alabama for robbery, and the state is requesting a 3-day extension. No more than that. They've never gotten an extension before. She also has some recent history right prior to that from Tennessee for indecency, strongly failure to appear, and so we're just asking for a 3-day extension.
I would be opposed to the extension of retaliation, had ample time to get to Cali, and we don't really will threaten the extension at this point.
It's only waived the, oh, it's been,
Right. And so they said, because I knew you wouldn't give the 4-day, I told them the morning of 18th, and if the court grants it.
I usually will give no more than 3 days, Ms. Kuhn. I usually give maybe one, you know, if it's serious enough, and no more than 3 days. Okay, I'll grant it, but
Thank you, Judge.
that's it.
All right.
Okay, yes, thank you.
I put them on, that's gonna go to trial. They just, it's set tomorrow, but it's, yeah, it's upstairs in felony right now. It's gonna go. I think so.
Hi.
Hey guys,
Hi.
I'm working on that off docket from yesterday. You ordered the removal of the GPS monitoring device, but you didn't have the pre-trial service.
Oh, right. Okay, so just,
Pre-trial, we couldn't get it, thank you for the.
okay, yeah, do you mind processing it and waive the signature? So is he here?
He's not here today. but
Okay,
I
so let
can
him know.
send
We'll
it
take care of it now. We didn't have a pretrial and we forgot.
Okay, no worries.
Oh, here,
No.
just so the court knows, file the notice of appeal.
Yeah.
Who did?
Me.
Okay, don't get your feelings hurt. It is what it is. Yeah, look, we had someone who who literally appealed it
Yes.
for 5 or 6 years?
It was a very long time. I think.
He spent more time here appealing it than what the original sentence was in Florida.
No,
This is very roundabout way to meet.
Do it. You do what you need to do. But at the end of the day,
Yeah.
I mean, like the other guy, he appealed it. He went to the CCA. He went to federal court. And at the end of the day, it was a 4-year sentence.
Yeah.
And he spent more time, he spent 6 years here or something appealing it, or 4 years, 6 years. But anyways,
I love making case law.
there you go. So where are we going now?
Well, so.
I'm gonna be filing capital appeals.
Right.
For now, I've just filed the notice.
Okay.
Placeholder
It's
to
a toll, yeah.
toll them actually coming to get them, like,
Okay.
Louisiana will come back. So,
I just filed the notice just as.
So how soon? Is it 30 days to get it in?
So the date hasn't changed. That's just giving them time for the appeal. And then if they don't actually file the appeal, then for appellate rules, it's going to kick it out. So this is just to give them the opportunity to file. the appeal.
But you do have what? Is it 30 days to
30 days.
file? Yeah.
And then.
Okay.
okay,
Good luck.
thank you.
Don't say that.
What's up, man? Done already? Okay. Have fun. Hi, Enrique. I signed your order the other day. Is that what you want, talking about? The order for discovery? Or you have something else? Sure. Thanks. Damn, that's a lot of emails you were talking about. A lot of emails that you were talking about earlier. Tell me. Does the state know of this? Okay. Is it just a standard discovery order? Yeah. You didn't modify it in any way?
It may be something in there about.
Because not, if it's just standard, then they've already agreed to it. But if you have modified it, okay, it looks like, I don't see anything that's been done. So, all right, I'll sign it. Hey, just to give you a heads up, he's filing just a standard discovery motion in one of his cases. It's 259 0852. I just want you to know so that you're not. Yeah.
And it's still
Etch. A lawyer. Uh-huh. And conditions that we need you to sign. Shoot.
I'm trying to figure, what is the probable cause, the other one we did?
We already did probable cause.
You said what?
We already did probable cause when you were standing here earlier.
Yeah, I'm trying, I didn't hear, what was the probable cause, because the last property is great.
Okay, we can't, ma'am. You have the right to remain silent. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. No, it's not fine. Let me get you a lawyer. I'll have you talk to the lawyer. Give me 10 minutes. I'm just waiting on them to come and then you can talk to the lawyer about it. Okay? Just please, just don't leave. What'd you get for?
Oh, it was one I had to wait on. I named it and qualified.
Okay, this is important. Judge Fleischer just said no more PR bond for you. PR bond means personal recognizance. You promise to show up, and they let you go free. Once you lose that privilege, you're sitting in jail until trial. That's a judge sending a message. I trusted you. You broke it. Now you sit. Harsh but fair.
You don't know yet? I think she's ready to go. She's ready to go. So.
I'll reset it. What stress case?
Ventura, she looks like she's. Oh, I submitted ours. Oh, right, it's okay, you did. Oh, don't worry. I don't need to get driving this is. No, you didn't. I was fine. I was just not getting the line. Oh, okay. Okay. Okay, so it shouldn't be. It should be. That would be. Yeah. Speak up and that you might.
Hey, Glenn, what's up, man?
Last round of the day.
I know. Distraction.
Actually, for, cheese, officer and or. Yeah, she can solar. Oh, yeah.